I rise to speak to the Justice Legislation Amendment Miscellaneous Bill, and I note that this bill represents significant legal housekeeping by the Minns government, and as such is a welcome change in pace. We've seen too many examples of slight bills, the Drug Misuse and Trafficking Amendment Appointed Persons Bill, for example, dealing with matters individually, which could just as easily have been incorporated into a statute law miscellaneous provisions bill together with other similar matters. So it is pleasing to see a coordinated approach, and this Justice Legislation Amendment Miscellaneous Bill, which seeks to amend 12 separate acts in the one bill. However, I also note that this bill has been considered by us in the same week as we considered the second of the government's statute law miscellaneous provisions bill, and one wonders why these matters needed to be considered separately and could not have been dealt with together. Apparently, the government feels no time pressure on its legislative agenda. What is not as pleasing is that 3 of the amendments found in this bill facilitate the creation or raising of fees payable by the public at a time of significant cost of living pressures. Changes to the Civil Procedure Act, the Dormant Funds Act and the New South Wales Trustee and Guardian Act are all designed to streamline the levying of a variety of fees. Any increase in fees or facilitation of future increases by government agencies is essentially a new form of taxation from a government which promised no new taxes. Most of the changes introduced by this legislation are sensible reforms which we are happy to support. The amendments respond to recent developments or recent case law and represent an appropriate and timely response. For example, as the Honourable Member has just noted, changes to the Bail Act clarify that a court must refuse bail on a detention application unless it is established that special or exceptional circumstances justify a decision to grant or dispense with bail, and it also allows a bail condition to be imposed requiring the accused to only be released on bail into the care or company of a specified person or class of persons. And the changes to the Children's Guardians Act aligns that act with our age discrimination laws and removes the requirement for the children's guardian to be under 65 years of age. It is not my intention to discuss each of the changes proposed by this bill. They have been well rehearsed by the Honourable Member in the second reading speech. I indicate that we are happy to support all of them, but we do have serious concerns about one of the proposed changes, and that one only because this bill provides insufficient information to Parliament and to the people of New South Wales to allow us to support this change with confidence. Schedule 3 to the bill seeks to amend the Fines Act by inserting new Section 23 capital B. This section provides that a penalty notice could be satisfied by the completion of prescribed activities in place of the payment of the monetary amount specified in the penalty notice. Importantly, all of the relevant detail, which persons, what activities, what class of penalty notices and any other additional requirements are all to be specified by regulation. That is, these details are not disclosed in this legislation. This change is couched in very general terms, but from the second reading speech appears to have been introduced to facilitate the government's policy announcement in relation to intervention rather than criminal fines for drugs other than cannabis. But of course, the operation of this section will not be limited by the words of the Minister found in the second reading speech. Once passed, it will be able to operate as broadly or as narrowly as the regulations provide, and so it will be important for us, in order to exercise our proper function of review, to watch the regulations made very closely. It is disappointing that this House is being asked to consider this legislation not on the basis of full details being provided to Parliament and the people, but on the basis of a short press release issued on the 10th of October 2023, which I note made no reference to the Fines Act and any necessary amendments thereto. This press release flagged the introduction of a policy in relation to providing health interventions rather than imposing criminal fines for drugs other than cannabis. This policy has echoes of the coalition policy announced in September last year as part of our $500 million response to the recommendations emerging from the ICE inquiry. I say echoes advisedly because we had a clear, detailed and funded policy response, whereas the government has given us a broad brush press release. So it is not yet clear to what extent the government policy facilitated by this change to the Fines Act, is consistent with our detailed policy. Indeed, until we see the regulations made by the Executive and not by Parliament, this House will apparently have no actual details of what the government's plan is. But we are being asked today to support this legislative change. The Coalition policy was clear. Recommendation 12 of the ICE inquiry stated, in conjunction with increased resourcing for specialist drug assessment and treatment services, that the New South Wales Government introduce a legislated police diversion scheme for use and possession for personal use of prohibited drugs. The Coalition response to Recommendation 12 was this: the possession and use of illicit drugs in New South Wales is and will remain a criminal offence. The New South Wales Government, that is the former Coalition Government, considers that successful implementation of a pre-court diversion scheme, that is what appears to be proposed in the government's press release and facilitated by this change to the Fines Act, is only achievable when relevant services and supports have been established in the health and justice systems. We were happy to look at a diversion scheme, but we wanted to make sure that the relevant services were in place and available to all as a first step. Our plan called for assessment, treatment and support, operating throughout the entirety of the state. We committed to establishing specialist drug assessment, treatment services and support statewide before a final decision as to the implementation of a pre-court diversion scheme would be made. In the media release of the Minns government, however, there is no evidence that this hard and important work has been done. Instead, it notes that the Commissioner of Police and the Chief Health Officer have advised the government of their, and I quote, operational readiness to implement the scheme from next year, end quote. Operational readiness to do what? Implement what? From what date? In what places? Being able to answer these details goes to good government, but it also goes to people's lives. This scheme is designed to help early-stage drug users. We should not pretend to help or help on paper, or not be ready to help everyone who wants help, or only be able to help in some locations but abandon others. If this is a real attempt at reform, then it needs to be supported properly. That was our plan. The government's echo is not as clear. Our policy was not an all-of-drugs policy. The Coalition policy envisaged that it would only apply to certain Schedule 9 or prescribed restricted substances. But the press coverage suggests that the Labor policy will apply to all illegal drugs. The detail, of course, is not clear and has not been provided to this House. If it does apply to all illegal drugs, has this been thought through? For example, how sure are we that a person arrested with a small quantity of the notorious date rape drug ketamine is intending to use it for themselves? Personal use may have different uses. A broad brush, poorly considered drugs policy could have dangerous but unintended consequences. And our policy was a whole of state policy, offered to every citizen. What assurance do we have that the diversion scheme and health supports will be in place throughout the entirety of the state, Sydney and the regions, before the scheme starts? It is important that all residents of New South Wales have equal access to any diversion scheme, and that we don't have a city policy and a regions policy. This is a law reform initiative, and if it will operate differentially based on postcode, this offends against important notions of equality of all before the law, a hallmark of any system based on the rule of law. The government's recent announcement flagged the introduction of a diversion scheme. They now present this legislation to amend the Fines Act, but we are being asked to approve legislative change before we see the details. We need these details now. It is irresponsible to introduce a major change in drug policy designed to support early users away from the pathway of addiction without ensuring that the proper and necessary supports in place have been funded and are available equally throughout New South Wales. The government has not addressed these issues in this House. They are not sharing these details with the people of New South Wales, and it is not clear what their drug plan is. It has echoes of our plan, to which we remain committed, but it is only a faint echo without all of the necessary detail. So we are happy to support the process of reform, but any proper principled drug diversion scheme requires those rehabilitation services to be in place before it commences. Otherwise, we will not have a consistent justice system in our state. There should not be regional inequities in dealing with drug offenders. With these comments and qualifications, the Coalition will support this bill.